So the purpose of this call is to go over the H-1B cap updates for 2026, both the things we know and the things we don't know. Then we'll also cover the common issues that individuals are bringing to us and the concerns that they're presenting around the presidential proclamation and the changes for H-1B cap for 2026. And just as a starting point for the H-1B cap, this is the year 2026. You might hear me refer to this as the fiscal year for 2027. I'm not future tripping here. The fiscal year for USCIS will open on April 1st. And so the lottery season that we're dealing with in 2026 is actually for the fiscal year for USCIS for 2027. So it's a little complicated, kind of a backwards way of doing it, but it's the way it's always been. And so if you're used to the H-1B, you're adjusted to this fiscal year terminology already. So let's dive in and get started on this. So our H-1B pre-registration. So we have detailed information on this now that the registration system is going to open on March 4th. This will open, it's expected to open at noon on March 4th, and we will have until March 19th at noon to submit all of our applications. So in this instance, we'll be submitting all of the registrations on behalf of employers and clients that we represent and ensuring that those get submitted by March 19th at noon. If you've been in this a while, you'll know that the registration system for the last 2 years has been extended because of technical difficulties, and we can't bank on that happening again. Even though it's occurred the last 3 times, we're not going to bank on that happening this year. After March 19th, USCIS is going to conduct the lottery if they have more petitions or more applicants than they have available slots. More on the available slots here when we get to our next screen, but the important thing here is there's a very good chance for the first time since 2012 that they may not meet the lottery numbers in this initial submission. And if they don't, none of the weighted selection process, I'll talk about that in a second as well, none of that is going to come about. It'll just be straight selection, H-1B as usual, no special procedures, other than your filing window. So your filing window is critical. If you miss this window, there is no second chance. The lottery is just a ticket. So going through this registration, even if demand does not exceed available numbers, you will still have this same window in which to get your petition submitted to the government. And that window will run from approximately April 1st until June 30th. So be prepared now with that deadline so that you have that firmly in your mind and you don't miss it, because once you miss that window, it's gone forever. All right, H-1B issues. So the first one, this one happened in September of 2025. The presidential proclamation was that for any H-1B holder that is outside the United States, so this on the application, this is where you're selecting consular notification, where the individual's abroad. There is a $100,000 rule that must be paid in order to file. We were hopeful that when this was announced that this would be implemented either at the consulate or at the point of entry. Unfortunately, the fee has to be paid by USCIS or they will reject the petition. And USCIS has also reserved the right to make this fee applicable after you file. So in cases where the individual failed to maintain status or left the country after the application was filed, it used to be that those things weren't a major deal. We made the adjustment and everything would be fine. Now that's got a $100,000 price tag. So that applies both to H-1B petitions that we can file now, so extensions, transfers, amendments. It also, though, applies to our H-1B registrations for selected cases. And this is an important thing to keep in mind as we go through this, and it will continue to evolve because it is guaranteed that USCIS will be denying changes of status for cap cases. And when they deny it, the implication is that you'll get a bill for $100,000. And if you don't pay that bill, you won't get the H-1B approval. All right, H-1B lottery for 2026. So as I mentioned previously, if the cap demand exceeds the cap, exceeds the numbers that are available, then we have this weighted selection. Wage level 1 gets you 1 count, so meaning 1 chance of being selected. Wage level 2 gives you, it's weighted in favor of giving you essentially 2 chances of selection. And so on to wage level 4. Now I've put in here the wage levels just to give everybody an example. These wages are real wages. These are for Oakland County for the position of a software developer. And so you can see the different wage levels that are likely that will be applied for any software developer applications where you're working, or where the candidate is working in Oakland County. The one part about this that is clear is in order for this to work, they have to alter the registration process to obtain this data from the employer, but then also to secure the employer's commitment to pay these wages in their petition. So there's going to be some mechanism that locks every employer that's registering in the H-1B lottery, that locks them into the wage that they've chosen. The additional thing that we do know about this lottery is that the registration fee is going to be $215. What's not clear yet is how USCIS is going to collect the wage level data. We just don't know, and they haven't said. And they may not say until the final rule becomes final. So a little backdrop, might be a little boring, but just a little backdrop here. In order to make this rule effective, USCIS published a brand new rule in the regulations for H-1B visas. And that new rule has to follow a 60-day notice and comment period, meaning the government has to post this registration, allow the public to comment for 60 days, and then it will become final. As has been current practice for many of these registrations, they've already said it's going to be final. Yes, we're doing the notice and comment, but we're going to do this anyway. And that effective date is the 27th of February, which gives them about 5 days before the lottery opens. It's anticipated that rule is going to be final and is going to be applied even aside from possible remedies or even the fact that this is not authorized and is inconsistent with congressional intent. The only vehicle that we can see where USCIS would be able to enforce the wage level that's chosen for the lottery. So wage levels are specific by occupation, by geographic location. The only vehicle that currently exists that would allow the government to collect this data and to lock it in place is a labor condition application. This has a big impact because it takes a minimum of 7 days to get the labor application certified. And without it being certified, there's nothing binding on the employer. But it seems inevitable to me that the LCA will be the requirement that is used, which means you'll need to plan ahead by an extra 7 days for getting your cases into the registration. Wanted to cover H-1B cap statistics here. So on the screen in front of you, you've got 6 years worth of data for the total number of registrations, the eligible registrations, meaning the ones that the government weeded out and the ones they actually worked with. And then people with double registrations, this really means nothing to our discussion. But government likes their data on this point. In their attempt to try and claim fraud in previous years, there wasn't any, well, I won't say there wasn't fraud, but multiple registrations are legal and still are. There's no point anymore, but they were legal then, they're legal now. So you can see on the right-hand side, though, this is the important part, the selected registrations. So as you can see from 2021, they were at 124,000, and that number for 2026 went to 120. So even though Congress has said 85,000 visas is what's available annually, USCIS brings other numbers in that they've recaptured from previous years. And so with this trend in line, it's very likely that our number of available slots is likely to be around 120,000. You can also see from the total number of eligible registrations that numbers are dropping. Demand is dropping. And with the changes in our industry, we expect that demand is going to drop further. Major tech companies were the largest users in every single year for the last 15 years of H-1B registrations, meaning they took home more than half of the H-1B lottery slots every single year. With them being called out with the $100,000 rule, with the possibility of paying $100,000 for individuals offshore, it's expected that big tech is going to drop their numbers, which we think will have a big impact on the availability for smaller employers and on the overall number of registrations that will be submitted. The lottery process, so what you need to get to us for any cases that you want to put through the lottery. So these are the required documents that we need from you. So we need a copy of the passport from the foreign national. We need the resume for the foreign national. We need copies of all their degrees. And we need an offer letter or other documents to establish what wage you intend to pay. So we've got an intake form that we'll be sending to anyone that wants to submit an H-1B lottery process so that we can actually collect the work location, job title, salary, all those details. And if you don't have that already from us, please reach out. We'll be happy to get that to you. In order to make these submissions, we have to do that by March 19th. We're reluctant to impose a firm cutoff date for employers because we want to support you as best we can. And we'll do that right up to the last minute. However, in your own planning, you need to plan to have any of your registrations that you want to submit to us before March 4th. And if there is a labor condition application requirement, then we won't have any chance of submitting a case after the 12th because we'd have to submit a labor condition application on or before the 12th to have it certified in time for the 19th. So bear those things in mind as you move into your planning for the H-1B selection. For selected cases, I wanted to hit this briefly, things that we need from you. So we need the specific work location, job description, offer letter, and employment agreement. And the offer letter and employment agreement will have to be consistent with what we put into the registration. Documentation to show that work is available for the employee. And then if the United States, a critical point for filing will be evidence that the foreign national has maintained their current status. And as I mentioned previously, this has potential for a $100,000 price tag. If an individual has not maintained status, even if it's through no fault of their own, there is a $100,000 price tag that would come with actually getting the approval notice. Current trends that we're seeing in the H-1B landscape. So I wanted to hit this briefly. Current trends are coming from two locations: increased enforcement and then request for evidence. In a request for evidence, we're seeing increased levels of questioning and scrutiny around what wage level is used on the LCA. And the number one thing that we're seeing is USCIS this goes hand in hand actually with the increased enforcement. So what we're seeing, these wage level questions are most often driven by a verification USCIS does with an end client or end user. And the end user will confirm the years of experience or the position requirements. And if that doesn't match up, then we can lose an H-1B for choosing the wrong wage level. And so in choosing your wage level, you need to be very careful on the front end and make sure that your end user or end client, if that's part of your picture, and it isn't for everybody, but if it's part of your picture, make sure that you're consistent on all levels and in all places. Specialty occupation. So this is going way up. And specialty occupation is very general. What I mean by that, though, specifically, is questioning what was chosen for the occupation, questioning the nature of the position, and attempts by the government to argue, hey, you chose the wrong occupation, or hey, your position doesn't fit within the occupation that you chose. Or even you don't qualify. We're seeing an increase in licensure questions. And then lastly, maintenance of status. So it's always been the rule that foreign nationals have to demonstrate maintenance of status from the date of their last entry and through the present. This is being capitalized on more and more. Historically, a maintenance of status question, if it came up in a request for evidence, it was, quarter page, 2 or 3 questions. Now it's 2 or 3 pages long with very specific questions, and they're looking at all aspects. And in some cases, they're going back even further than the last entry. So this is, and as I mentioned previously, this now has a $100,000 price tag. If you aren't successful on that issue, the only way you're getting to an approval is by paying the $100,000 fee. On the increased enforcement side, we've seen an uptick in fraud investigations. We're seeing an increase in verification of job requirements. This type of verification goes to the employee, to the employer, and then to any third parties that might be involved. We're seeing an increase in employer site visits. So whether you have employees working in-house at your location or working at a third-party location, you're still subject to this being visited for your main place of business. Consular verification. So these are verifications from the Department of State. These are also significantly on the rise. And in some cases, 221Gs are being issued. So for those of you who don't know, when I say 221G, I'm referring to administrative processing. And the Department of State has increased the number of administrative processing cases that they issue so that they can conduct the verification in the United States. And lastly, employee site visits. So this is visits to the employee, even if their work site is from home. These visits are happening, and we're seeing about a 20 to 30% increase in these visits over the last 6 to 9 months. So some projections from our office. Number one, as I mentioned already, we're expecting low demand for the H-1B lottery slots compared to prior years. We also projected this would benefit smaller employers. We're projecting that litigation would take place for the weighted selection process. Again, that would be it, and I think that will happen regardless of whether there actually is a weighted selection or not. As I mentioned, if there aren't enough numbers, there won't be a weighted selection. They'll just select all cases. But even if that's how this plays out, we still expect a litigation challenge on this. It's unclear, and I think it's doubtful that we would get any type of injunction or quick action that would prevent this wage-based selection from going into play this year. So any impact is likely to be for next year. Our next projection is that the labor condition applications would be required, and I covered that previously. So plan ahead. I'll reiterate that again, though. Plan ahead for your H-1B selections so that you have enough time to do a labor condition application. Lastly, on this, an additional projection. So the $100,000 rule is expected to end on the 20th, of 2020, September 20th, 2026. It would take an executive order to extend that, and it's unclear whether that would be extended, but at this point, I'm a bit of a skeptic. I don't think that would be extended. And that's good news for any changes of status for the H-1B cap cases, because if there's any doubt around someone's maintenance of status or whether they're currently in status, maybe they did 2 master's degrees and they're on F1s or something like that. If you file with regular processing, you may be able to avoid the $100,000 rule just by running the clock out, because any H-1Bs that are filed for this year's cap, the earliest start date is October 1st of 2026, which is after the presidential order requiring this $100,000 fee will expire. Some updates from Luke Bowman Law. And actually, before I get to this, one other piece that we recommend is that individuals in the United States, going back to this $100,000 rule, if an individual is in the United States on any status, it's presumed that they are not subject to this $100,000 rule. Meaning, if they're here as a visitor, if they can get here on any other status, H4, F2, L2, any status, as long as they're physically present before you have to submit the petition, meaning before June 30th of 2026, then you'd be able to avoid the $100,000 rule by seeking a change of status. So bear that in mind with your registrations. Even if an individual is abroad now, but they have the possibility that they could get here before June 30th, then I would strongly encourage you to still put them through the H-1B registration. The registration fee is still pretty low. So even if you choose not to file and you're selected and you choose not to file, it's still worth the risk, in our opinion, to get the individual through the lottery. One of our other questions that we received prior to this call is when it comes to the work location for setting the wage that's needed for the H-1B weighted process, what happens when you've got 2 work sites? This is another reason why I believe that labor condition application will be required, because there's already a provision for dealing with 2 work sites built into the labor condition application. The short answer here is that the prevailing wage, the highest of the prevailing wages, must be paid for both locations. So let me give you an example. Let's say an individual lives here in Michigan. They're working for a company in California, and they will go to California every 2 weeks to work on the project there. Obviously, if there's a big wage disparity because of the cost of living between Michigan and California. With 2 work sites like that, number one, yes, you can do 2 work sites. Yes, you can put it through the registration. However, you're going to be locked into the highest of those 2 prevailing wages at all times. And so to hit a wage level 3 or wage level 4, you're going to have to pay the prevailing wage at a level 4 or level 3 for California, even though the individual's living and working in Michigan for part of the time. So bear that in mind with your filings as well. The highest of the prevailing wages must be paid. And so if you're committing to a wage level 3 or wage level 4 and you've got multiple work sites, then the highest wage is what you're going to be stuck with. A couple updates now from Luke Bowman Law that we wanted to hit for you. Number one, follow us on YouTube, LinkedIn, other social media. Just search for Luke Bowman Law. We're making regular updates to our social media, both in terms of our practices, our recommendations, but also changes in our industry. We've also got a regular publication now from the desk of Luke Bowman for critical updates. So make sure that you're getting those. If you're not, contact us or sign up on our website. And then easing the access to the attorney. So this is always a challenge, and the number one complaint for immigration attorneys is that you can't talk to the attorney. So we're addressing that in 2 ways. One, for individuals, you can always book an appointment right on our website, and you've got real-time availability, including same-day availability. For employers, we want to stay connected with you. We want to make sure that if you're actively working with us, there's no cost to you to do this. So if you don't already have the link where you can book directly with us at any time, please contact us after this call, and we'll be happy to provide you with that link so that you can schedule with us and we can talk through any issues that you have and cover your questions regarding both H-1B lottery, but any other questions as well. And that brings us to the end of our call for today. And if you have some questions, I'll leave this open for just a few minutes at the end of this if you want to drop any questions into the chat, and then we can contact you after the call to answer those questions. But as always, our email address is right here. Feel free to take that down and reach out to us. And then this QR code, feel free to scan that. That will take you to our website where you can book an appointment if you want to talk to us about specific questions about your case that may have come up during this call. Thank you guys for joining us. I hope you all have a wonderful day.